Hi, I'm Beth Walensky, legal practice professor at the University of Michigan Law School. Today I'm going to talk to you about writing the introduction section of a piece of persuasive writing. And by persuasive writing, I'm referring usually to a motion or a brief that you file in court. Remember that the introduction is the very first part of your motion or brief. It's the first thing the judge reads. So we're going to look at some examples today. Before we do that, though, I just want to briefly show you where the introduction goes. You can get a sense of how this fits into your overall document. If you have a long motion or brief that has a table of contents, the introduction is likely to have its own heading. For a short motion, for example, a discovery motion or a motion for an extension of time, or even in some cases, a motion to dismiss or a motion for summary judgment that's not particularly complicated, you might not have a table of contents. And in that case, the introduction would start immediately after the caption, and it wouldn't even need its own heading. It would look like this. So let's look now at some examples of actual introductions from motions filed in court. The first example comes from a lawsuit called House versus Napolitano. In this case, the plaintiff, David House, sued the United States government for allegedly violating his rights under the Fourth Amendment, right to be free from unreasonable searches and seizures. One thing to keep in mind is that a judge picking up a motion is unlikely to know or remember what the lawsuit is about. So the introduction needs to convey enough information to make sense because the judge won't have read any of the facts at this point. For that reason, I'm not going to give you information about this lawsuit until you've read the introduction, and we'll see how effective it is. So first, let's look at the introduction from the government's motion to dismiss the complaint. One thing to keep in mind is that while these examples come from actual motions filed in court, I have edited them slightly for the purposes of this video. So at this point, I'd like you to pause the video to briefly read through the introduction, these two paragraphs, from the government's motion to dismiss the complaint in House versus Napolitano. Now let's look at some things that make this introduction particularly effective. First, it doesn't assume that the reader, the judge, already knows anything about this case. It starts with two sentences, these two, that tell the reader that this is a motion about unreasonable searches and seizures. And the next two sentences then provide more specific information about what this lawsuit is about. Notice here that the introduction focuses on the law instead of providing much detail about the facts of the plaintiff's specific case. That's effective here because the law in this case happens to favor the government's position. So we don't get a lot of detail about what the plaintiff is alleging. We know that the lawsuit is about an allegation that the U.S. government has violated his rights against unreasonable searches and seizures because of the way it took and searched and seized his electronic devices. But that's mostly the information that we get, and then the government focuses on the law. Notice also that in focusing on the law and in providing the background information about the case, the government uses persuasive language and framing. So it emphasizes in multiple places that the law is very much in the government's favor. It uses phrases like well-established and extensive and long-standing to describe the government's authority to conduct searches and seizures of things at the borders. It describes the plaintiff's request as asking for a new exception to long-standing settled law. And then the last paragraph, the government addresses several specific arguments the plaintiff makes. The plaintiff apparently, we can learn from just reading this document, that the plaintiff argues that the contents of his electronic devices matter, and so the government briefly addresses that question. And then it also addresses the plaintiff's contention that the government detained his devices for an unreasonable length of time, and it briefly addresses that. Finally, at the end, the government states clearly what relief it's seeking. It wants the court to dismiss the complaint under Federal Rule Civil Procedure 12b-6 for failure to state a claim. Keep in mind that it's essential to state what relief you're seeking when you're filing any sort of motion. You can put that at the end of the document, at the end of the introduction. You could also put it at the beginning of the introduction. You can start an introduction like this. The court should dismiss the plaintiff's complaint pursuant to Federal Rule of Civil Procedure 12b-6 because, and then you would launch into your argument, the introduction to your argument. Okay, now I'd like you to take a look at the opposition to the motion to dismiss that David House filed in response to the government's motion. Again, pause the video now so you can read these paragraphs, and then we'll go through parts of them together. So first of all, ordinarily, if you are writing the opposition to any sort of motion, you can assume that the judge has just put down the motion that you're opposing and has picked up your opposition. In other words, you can assume that the judge actually does have some information about what the case is about because he or she will have just read the other side's motion. This opposition to the government's motion to dismiss happens to do a nice job of introducing the overall lawsuit to the reader. It wouldn't necessarily have to do that again because the plaintiff here could have taken the approach of jumping a little bit further into the introduction and into the argument on the assumption that the judge had just read the government's motion. So notice first that the opposition focuses much more on the facts. It describes the government as having taking the plaintiff's electronic devices from him at the border, the nation's border, keeping them for 49 days in order to make copies. The government retained the copied information indefinitely, examined and analyzed the information, shared that information with other parts of the federal government and potentially with foreign governments as well. It also says that the government concedes that the plaintiff was targeted because of his lawful associational activities. So in the government's introduction, we did not learn exactly what the government had done when it searched and seized the plaintiff's electronic devices. We get those details here because those are facts that are very favorable to the plaintiff. So the plaintiff's introduction focuses on those facts. Then, when the introduction does turn to discussing the law, it frames the law in a way that makes the government's position appear extreme. It describes the government's position as suggesting that the government's power to search electronic devices is without limit and effectively beyond judicial review. And it describes the logical result of the government's argument as permitting the government to seize property and hold it even for years. Again, ways of describing the law that make the government's view of the law sound extreme. And it describes the government as offering a litany of excuses for the 49-day delay in returning the plaintiff's electronic devices to him. Finally, the introduction ends with a clear statement of what the plaintiff wants. The plaintiff wants the court to deny the government's motion to dismiss. So now that we've seen two introductions, let's go back and list some of the things that make an introduction effective. First, a good introduction captures the reader's attention. You don't want to bore the reader at any part of your document. The introduction is an especially important place to not bore the reader. You want to be persuasive from the first sentence. This should not be a dry recitation of what the legal standards are. You may need to include that in some part, perhaps at the beginning of your argument section, but the introduction is your chance to introduce your story. Third, as I've already mentioned, a good introduction doesn't assume the reader has any knowledge of the case. That's if you're writing the motion. If you're opposing a motion, then you can assume that the reader has just read the other side's motion before picking up your opposition, so you can assume some knowledge. A good introduction conveys your overall theme or story. This is something that's really important in persuasive writing, not just in introductions, but in thinking through your entire motion, really in thinking through your entire case. You can think of it this way. What if somebody who wasn't a lawyer, a family member, said to you, "Tell me about the case you're working on," and you wanted in a couple of sentences to explain what the case was about and why your side would win? Think about how you would explain it in a persuasive, compelling way without using a lot of legalese, a lot of legal terms, but really just conveying the essence of why your client ought to win. That's what you want to do in the overall motion, and that's what you want your introduction to convey. And finally, a good introduction clearly states the relief you're seeking or clearly asks for the denial of the relief the other side seeks. So those are the do's for a good introduction. Now let's look at some of the don'ts. What should you try to avoid doing in drafting an introduction? You don't want to be vague. Notice, for example, that in House versus Napolitano, the government's introduction didn't simply talk about how the government has historically had a lot of discretion in conducting searches and seizures. Even without getting too much into the facts of the case, it focused on searches at the border. It focused on searches of electronic devices, the specific things that this case is about. If you draft an introduction that is too vague, then it's really not doing any work. Talking about how important it is to give the government the ability to conduct searches generally doesn't help your reader understand why you should win this case. A good introduction doesn't bore the reader with a dry statement of legal standards. It doesn't include a bunch of legal terms that you have yet to define. Remember that this is your chance to tell the story using natural language without having to resort to specific legal terms. So the intro should do those things in a very reader-friendly way, not in a legalistic way. Notice also that the introduction and the opposition from the motion to dismiss and from the opposition to the motion to dismiss didn't cite to any authority. The introduction is the one place where you really don't need to cite to authority. And in fact, citing to authority can be distracting. So you should have in your mind what legal authorities are going to support the points you make in your introduction, but the introduction is not the place you need to include them. Don't include dates unless they are essential to the motion. Again, those can be some dry details that aren't essential to conveying your reader's story. And finally, don't make the introduction too long. The examples that I showed you from House versus Napolitano were from a motion and an opposition that addressed a number of complex and lengthy legal arguments. So the introductions were two somewhat lengthy paragraphs. For a motion that's only 10 to 12 pages, you may need a single paragraph to convey in a short and sweet way what the motion is about. Now let's look at some examples of less than effective introductions. These examples come from a motion for summary judgment and an opposition to the motion for summary judgment in a lawsuit called O'Neill versus Mermaid Touring. So this now is the defendant's motion for summary judgment. It's the introduction, to the defendant's motion for summary judgment. Pause the video now to read this paragraph. So what's wrong with this introduction? Well, first, it seems to assume that the judge or any reader already is familiar with the case. It jumps right in and starts stating what the main legal takeaways are. From reading the introduction, the reader can probably figure out that this is a case about how much the defendant should have paid the plaintiff for her work, and from that can probably figure out that the plaintiff must work for or at one point have worked for the defendant. But beyond that, we have no sense of who these people are, what their relationship is to each other, what the defendant's overall story is for why the defendant ought to win. And second, nothing about this introduction is persuasive. It's simply a dry recitation of the defendant's four main legal arguments, with no sense of what the overall story is from the defendant's point of view. So while this list of the four reasons the defendant ought to win is something that the defendant might need to include further down, for example, at the beginning of the argument section, it is not an effective way to introduce the whole motion. So now let's take a look at the plaintiff's opposition to the defendant's motion for summary judgment in O'Neill versus Mermaid Touring. Again, pause the video now to read the introduction to the opposition. So this introduction does a better job of explaining what the lawsuit is about and conveying some of the overall themes. But again, it doesn't do so in the most effective way. Let's talk about and look at why this introduction isn't as effective as it could be. So the first and the biggest point is that it buries the most essential stuff several paragraphs in. So this first paragraph is about personal assistance to megastars generally. It doesn't tell us much about the plaintiff's claim. And then when it does get to specific information about the plaintiff's lawsuit, it still uses pretty vague language, and it also uses language that is over the top, melodramatic, and is therefore not especially compelling. Again, even at this point, one paragraph in, I still don't know why this plaintiff ought to win. The second paragraph is a little more specific to the plaintiff's case, but it still tells us nothing about why this plaintiff ought to win. As reading this, I have no idea what the relationship is between this description of how hard Lady Gaga works, what the relationship is between that description and the plaintiff's allegations. Finally, in the third paragraph, we get to the good stuff, the stuff that I think is the most effective here. This paragraph actually works well because it conveys an overall theme that is persuasive. It hints at what the legal standards are that dictate why the plaintiff ought to win without getting bogged down in the dry details of state statutes about overtime compensation. So this paragraph works well, but it really should be more of the focus of this introduction. So this is an alternative that I've written to the introduction to this opposition to summary judgment. And by this point, you probably have figured out that this is a lawsuit that was filed against Lady Gaga and her touring company by her former personal assistant, Jennifer O'Neill. And Jennifer O'Neill is claiming that Lady Gaga did not pay her for all of the hours that Ms. O'Neill worked as her personal assistant. So I suggest starting with that third paragraph, the one that actually works well, and just tweaking it a little bit at the beginning to better introduce the key points, and then jumping straight to the last paragraph, leaving out all the other details about the state law, which we'll get to later in this motion. So I've eliminated those first two paragraphs in favor of two sentences that get to the point quickly and tell the key story in a direct and persuasive way, but a way that is not overblown or melodramatic. So here's what it says. This lawsuit is about how a tremendously successful entertainer took advantage of one of her key employees by overworking and then underpaying her. The defendant, Stephanie Germanotta, better known as the entertainer Lady Gaga, by her own admission frequently works 24 hours a day doing 6 shows a week. Notice also that those first two sentences now connect directly with the point about the plaintiff being Lady Gaga's only personal assistant. The overall result is an introduction that is short, focused, and persuasive. And finally, this alternative introduction continues to use the last paragraph that was in the original because it succinctly states what specific relief that the plaintiff is looking for. The plaintiff's asking the court to deny the defendant's motion for summary judgment. So that's an overview of how to draft an effective introduction. A few closing thoughts. First, I strongly urge you to wait until after you've drafted your motion, the overall motion, to go back and draft the introduction to the motion. The reason for that is that you often don't know what you want to put in the introduction until you finish the rest of the document. Writing the rest of the document will help you figure out what your key points are, what the narrative thrust of your story is, and will help you make sure that you've got a core theory that works for the entire thing. Once you've done that, you can draft an introduction that conveys that information in a short and succinct way. And the final point I want to leave you with is this. Introductions are challenging to draft. As you've probably figured out by now, you have to balance a number of competing interests. You need to convey enough information about the case so that it makes sense to a reader who's not familiar with it. But you also don't want to get bogged down in a lot of details about the specific facts or the details of the law. And you need to be persuasive and compelling in a short amount of space. So I encourage you to not think you can sit down and draft an introduction very quickly, but instead to force yourself to go through several versions of it until you get it just the way you like it.